Mm-mm. 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 Go, buddy, go.
Good morning, everyone. Looks like we've got everybody. Doug, we ready to go, sir?
We're ready, Your Honor.
All right, thank you very much. Good morning, everyone. My name is Chuck McLean, the Chief Public Utility Law Judge here at the Maryland Public Service Commission. Today is May 3rd, 2022. It's approximately 11 p.m. in the morning. We're here in case number 9675 for a pre-hearing conference, and the case is captioned Waypost Solar Project LLC's application for a certificate of public convenience and necessity to construct a 92 megawatt solar photovoltaic generating facility in Caroline County, Maryland. Why don't we start with appearances? We can start with the company.
Morning, Your Honor. David Bugelman's on behalf of the applicant, Waypost Solar Project LLC. I'd also like to enter the appearance of Mr. Maxwell Cook as co-counsel on behalf of the applicant. Thank you.
Good morning, sir.
Good morning.
PPRP.
Good morning, Your Honor. Sandra McLemore on behalf of the Power Plant Research Program. Also, I'd like to enter the appearance of Steve Tolson.
Good morning, ma'am. OPC.
Your Honor, Frederick H. Hoover on behalf of the Office of People's Counsel.
Good morning, Mr. Hoover and staff.
Good morning, Your Honor. James Greger on behalf of staff.
Good morning, sir. And last but not least, we have the Baltimore, Washington Construction and Public Employees Laborers District Council. It's quite a mouthful.
I know, and the abbreviation is not any better. My name is Gabi Ulrich. I represent the district council in this matter.
Thank you very much, ma'am. All right, Mr. Bugelmans. We have a procedural schedule or anything you want, or you want to start with the certificate of publication, sir?
Sure. I have a few exhibits to move into evidence. We would like to address the proposed intervention by BWLDC. We can handle it in whatever order Your Honor would like.
Why don't we go through your exhibits first, and we'll get to that afterwards.
Thank you, Your Honor. So we have two exhibits we'd like to mark and enter this morning. The first, as applicant exhibit 1, is the notice to Queen Anne's County, the compliance filing associated with that, consisting of 3 pages, which was filed on January 26, 2022.
Okay, all right, we'll mark that as applicant exhibit 1 for identification. And what's your second one, sir?
Thank you, Your Honor. As applicant exhibit 2, we would like to mark the certificate of publication for this pre-hearing conference, consisting of 2 pages filed on April 28th, 2022.
All right, we'll mark that as applicant exhibit 2. Are there any objections to applicant 1 and 2's admission? All right, seeing none, they are admitted. All right, we can jump to the petition for intervention. Mr. Bugelmans, I assume you're opposing it?
Well, we have some concerns, Your Honor.
Okay.
As Your Honor is aware, there are 2 instances under the Public Utilities article that require the Commission to deny a petition to intervene. First, the Commission must deny a petition to intervene if the parties to the proceeding adequately represent the interests of the person seeking to intervene. Here, BWLDC has stated its members have a general interest in, quote, renewable energy and equitable transition to renewables and implementing Maryland's climate goals. Respectfully, these broad policy interests are represented by PPRP on behalf of the state, which completes a comprehensive review of these applications on behalf of the entire state government, which includes renewable energy and climate change impacts. In addition, staff and OPC often focus on these issues either in testimony or briefs. It's not clear from the petition to intervene what BWLDC can add to this information when the entire state government is literally here and present to address these issues. And this is because the interests of BWLDC's members in this regard are no different than the general public. The second situation where the Commission must deny a petition to intervene is where the issues that the person seeks to raise are irrelevant or immaterial. And this is perhaps the more serious concern here. On this point, we do have an example of BWLDC attempting to raise relevant issues in CPCN proceedings. In case number 9663 in 2021, BWLDC provided public comments related to labor issues and recommended that the commission adopt labor standards and reporting requirements related to jobs in a CPCN order. And to support these comments, BWLDC cited to House Bill 298, which passed during the 2021 legislative session. At the evidentiary hearing in that case, Judge Grace asked counsel for the parties about the relevance of these issues to the commission's review and CPCN proceedings, and it's the same issue here. In that case, we argued that HB 298 amended only the Public Utilities Article Section 2-113A2 to require the commission to consider labor standards in the regulation of public service companies. Public service companies are very clearly defined to include electric companies, gas companies, water companies, basically regulated distribution utilities, and independent power producers such as the applicant do not fall under that definition. That was even covered in the perennial decision as part of the decision there. In addition, it's also important to note that in that same bill, the General Assembly added new factors to the Commission's due consideration review for CPCN applications, but only with respect to climate change impacts and benefits, not labor and employment issues. We also saw legislation in this year's legislative session, which would have imposed labor standards on generating stations through the CPCN process. However, that legislation did not pass. I think read together, this demonstrates an intent from the General Assembly that these issues are outside the scope of CPCN review, relevant for public service companies, obviously, but irrelevant for generating stations. That's I would submit for good reason, because CPCN's focus on a site-specific analysis designed to address and mitigate siting impacts to the surrounding area. Judge Grace apparently agreed with that argument, and her order didn't include any discussion on this issue. BWLDC does not state in its petition that it wishes to raise these arguments again, but it does make clear that it's here representing the interests of construction workers who build solar farms. And our concern is that this does seem like a logical direction that it may take if granted party status, because these are the interests that this group typically represents. So ultimately, based off of the petition that was filed, the applicant believes it would be beneficial to hear from counsel for BWLDC whether it wishes to raise these types of issues. So perhaps the petition to intervene could be more adequately assessed. Finally, to the extent Your Honor grants the petition, we would respectfully request that BWLDC's participation be limited to relevant issues, and the applicant would reserve the right to move to strike any testimony that it believes to be irrelevant or immaterial. Thank you, Your Honor.
Well, I hope that all issues are relevant. I'm not a huge fan of seeing irrelevant issues from anyone, but ma'am, is it Ulbig or Ulbig?
Ulbig.
Ulbig. I'm sorry, ma'am. Would you like to respond?
Yes, I think the applicant makes the issue way more complicated than they are, and at this point I was not involved in that previous proceeding that counsel references. So if the judge would like to have specific answers to the allegations that he puts forward, I would request to be able to respond in writing.
Well, I'm not as concerned about the previous proceedings, because if I'm correct, Mr. Bugelman, those were public comments. The BWC, well, I'm sorry, what's the best? BWLDC.
LDC.
Right. I mean, they weren't even a party to that case. So is that correct, Mr. Bugelman?
That's correct, Your Honor.
Yeah, and I understand your concern. I don't know that we need to get too far afield in terms of specific issues that they're going to raise at this point based on that. Did you want to respond to anything the applicant said other than that previous proceeding, ma'am?
Sure. Thank you. So we do represent construction workers in Maryland, about 5,000 of them, and some also in Caroline County. Our members have participated and have built solar projects And we believe that we have relevant information, particularly with regard to the economic impact that this project will have. The applicant writes in his notice, in his application, it speaks of the economic impact, about the jobs that it will create, and long-term, indirect, direct jobs. And I believe we have relevant information to that effect.
And have your members worked on Maryland solar projects, ma'am?
Yes, one specifically is it Todd Solar Farm, CPCN case number 9412.
All right. All right. Okay, great. All right. All right. Thank you, ma'am. Does anybody else want to be heard on the petition before I go back to Mr. Bugelmans? All right. Mr. Bugelmans, I mean, how do you respond? I think, in terms of the economic impact, it's certainly a different perspective than PPRP. Would you agree on that?
I would agree in a way, Your Honor. But I mean, my concern is that when the commission looks at the job creation benefits of projects, one of the required pieces of information are the creation of full-time equivalent jobs, that kind of thing. But again, our concern based off of past experience is that we could start delving into specifically what kind of workers are hired, issues like that, which respectfully I would submit are irrelevant to the siting of a project in a particular location. So, I mean, that's really the crux of our concern. I mean, obviously the economic impacts are considered, but there's a point at which it just becomes irrelevant to the case.
Understood. Well, I understand your arguments. I'm going to grant the petition, but obviously, if there are things that you believe are irrelevant, we can certainly address those at that time. Okay.
Thank you.
Thank you. All right. Do we have a procedural schedule proposed or agreed upon, Mr. Bugelmans?
We do, Your Honor.
Excellent.
It's been agreed to by everyone except BWLDC, so I could read the dates to Your Honor,
Okay.
and then council
Please
could
do.
perhaps chime in on the dates.
Okay.
So the first due date, Your Honor, would be the first public comment hearing, which we propose to hold the week of May 31st, 2022.
Okay, sir.
Next up would be the due date for the applicant's direct testimony, which would be June 16th, 2022.
All right. I got you.
Next, the direct testimony from all parties besides the applicant would be due on October 4th, 2022.
Could you repeat this, please? October
It would be
Which date?
October 4th, 2022.
4th. Okay.
Next, Your Honor, would be the second public comment hearing, the week of October 17th, 2022.
No. Okay, go ahead, sir.
Next would be the settlement status update to Your Honor, which would be due as a filing on October 20th, 2022.
All right.
And then finally, the evidentiary hearing in the event of no contested issues would be on October 25th, 2022.
Okay. Ma'am, how do those dates sound to you?
Yeah, I think they're okay, actually.
Okay. All right. Excellent. All right. I think those are fine. Mr. Bugelmans, in terms of the public hearings, do you have a preference, or does anyone have a preference in terms of whether or not the first one should be in person or virtual?
Yeah, that's a good question, Your Honor. I mean, I think that there's pros and cons to both. I think we've seen over the past 2 years, these virtual hearings do increase access for some folks, but perhaps for others, it's more difficult. Thinking about this, one way to do it would be to do the first one virtual, the second one in person. I mean, the Public Utilities article does refer to a hearing in the county, right? But it only needs to be one. So that could be a way to do it. You get the benefits of both. But the applicant wouldn't be opposed to both being virtual or in person.
I would definitely like to do at least one in person. Mr. Hoover, do you have a preference one way or the other?
Well, I'd say I don't have a strong preference. I mean, I've had experience in other solar siting cases that were much more controversial than this one. And it seemed that the virtual hearing process allowed a fair amount of participation by the interested folks. There didn't seem to be the technical issues that sometimes arise in these things. So it appears that the virtual hearing has worked pretty well. So Mr. Bugelman's suggestion of maybe doing the first one virtually and the second one in person makes sense to us. So.
All right. Does anybody else have a strong feeling one way or the other? All right. Seeing a lot of head shaking. All right. All right. Why don't we do that then, Mr. Bugelman? We'll plan on the first one being virtual and the second one being in person.
Thank you.
All right. Do we have anything else?
If I may, Your Honor.
Yes, ma'am.
Counsel, would you send the schedule that you read out loud? Would it be possible to get it in writing?
Sure, I'm happy to email it to you. I think that the judge will probably release a procedural schedule too that the parties will receive. So that's probably your best bet to have the official thing.
Okay, well, just in case, let me just run through these one more time and make sure I can read my chicken scratch. First public hearing, which will be virtual, will be the week of May 31st. Do we want to pick that date now since we got everybody?
Sure.
Is there a day that doesn't work for anyone that particular week? I mean, that Monday is obviously not going to work.
Your Honor, that Friday will not work for me.
Okay, yeah, I was going to try and avoid a Friday as well.
I could propose maybe June 2nd.
All right.
Can we do it June 3rd if at all possible? June 2nd isn't.
June 2nd.
I can make it if there's no other possibility, but.
Okay, so well, the June 3rd is a Friday, so how about June 1st? So Wednesday.
That'd
All
be
right,
perfect. Thank you, Your Honor.
What? Okay. All right. So let's go with June 1st for the first public hearing. The applicant's direct will be due on the 16th of June. Reply testimony will be on the 4th of October. The second public hearing will be the week of the 17th of October, and a settlement status on the 20th of October. Is that correct? With evidentiary hearings on the 25th of October.
Yes, Your Honor.
Okay. All right. Very good. Anything else?
No, Your Honor.
All right. Well, thank you all very much, and look forward to seeing everyone on the 1st. Take care.
Thank you.
Bye, everybody.
Thank
All right,
you.
we're off the record.
Off the record, Your Honor. Thank you very much.
Thank you.